Major breaking news. The United States Supreme Court has announced that on Monday, that's right, this Monday, before the 4th of July weekend, they're going to conference, which means they're going to sit down, all 9 justices in a room together with no one else, and they're going to decide whether or not to hear one or more of a whole host of Second Amendment related cases, which we will likely hear about the results on Tuesday. So this is a big deal, folks. It's going to tell us a lot about where the U.S. Supreme Court intends to go over the next 6 months with our Second Amendment rights. Stay tuned. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, and member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed: What the 10/7 Attacks on Israel by Hamas teach Americans about the right to bear arms. Check it out on Amazon.com. Israel Disarmed. You'll like it if you like the Second Amendment. A lot of good information in there, including a lot of history. Okay, folks. So here's the story. The Supreme Court announced on Friday that on Monday, that's right, this Monday, before the 4th of July weekend, the 9 justices are going to sit down in a room by themselves, and they're going to conference. They're going to conference together about what additional cases they want to hear on the merits this fall for their upcoming 2024-2025 Supreme Court term. And there is a list of Second Amendment cases that they have now announced that they're going to consider for cert grants on Monday. Now, I'm going to talk about these cases, and there's no guarantees that the court wants to hear any of these cases or will hear any of these cases. But this is what we should be cheering for, and this is what's going to be happening on Monday. And the good news is, I suspect the Supreme Court is going to make judgments and final decisions whether or not to hear some, all, or none of these cases. And we will likely hear the results of whether or not 4 justices voted to hear one or more of these cases or none of these cases. We should hear the results of the Monday conference probably on Tuesday. So it will be a very fast turnaround time, which is a little bit unusual for the court system, but that's a bit of good news for us here in the Second Amendment community. Because whether it be good, bad, or ugly, at least we'll know the answers on Tuesday. So to begin with, there are really 3 sets of Second Amendment cases up on cert, meaning whether or not the Supreme Court will hear the cases on the merits and grant cert. The first case is the Antonyuk case. The Antonyuk case, as you may recall, was out of the United States Court of Appeals for the Second Circuit in New York City. And the 2 questions presented, at least what's being proposed by the Antonyuk plaintiffs, those 2 questions the court should consider, is whether or not the proper time period for interpreting the meaning and the scope of the right, the Second Amendment, is either 1791, which is when the Second Amendment was adopted, or 1868, which of course was when the 14th Amendment was adopted, and that is the constitutional amendment that applied the Constitution, if you will, or I should say the Bill of Rights and the individual rights components, to the states and localities. 1791 or 1868, I've written on this before. My guess is the Supreme Court will not grant cert on that question because they just indicated in the Rahimi case that they're going to leave that on the table, saying that they're not going to resolve it right here and right now until they need to. The other question proposed by the Antonyuk plaintiffs and their counsel is, after Bruin, is it constitutional under the Second Amendment for states and localities to require the showing of good moral character before you can get a concealed carry permit? Now, this is a very interesting question presented in light of Rahimi, because if you may recall in Rahimi, one of the favorable good things that the Supreme Court said in Rahimi, which of course is the decision that upheld 18 U.S.C. 922 G8, individuals subject to domestic violence restraining orders cannot possess firearms. They upheld it in a narrow way, but they did so facially, allowing for as-applied challenges. But what the Supreme Court specifically said, though, was that they were outright 9-0, unanimously rejecting the government, the Department of Justice's argument that not responsible people, irresponsible people can be denied their right to keep and bear arms, that not responsible people can be disarmed. And that is an issue that speaks directly to these states like New York that say they require someone to show good moral character to get a license, because good moral character is basically that you're a responsible American. The Supreme Court just said that's a no-go zone. That's not considered, and that was unanimous. Even the liberals signed off to the notion that you don't lose your constitutional rights if you're simply not responsible. Rahimi says you got to be a credible threat to physical violence toward a third party to be disarmed, and even there you're only being disarmed temporarily for some period of time, not forever. So anyway, I think that I would like to see in the Antonyuk case, if they're not going to grant cert, which I'm guessing they won't, I think it's just premature, I would like to see them GVR, which means to grant cert, vacate the lower court decision, and remand for further consideration in light of Rahimi on the question of good moral character as a prerequisite or as a component of a requirement to get your permit, your gun permit, your carry permit in the state of New York. I'm not sure that the Supreme Court will do that because the Antonyuk case is still in the context of a preliminary injunction. It's an interlocutory appeal right now. So I think there's a good chance they will just deny cert, but I think there's also a possibility that they will GVR this case, referencing Rahimi, especially as to the good moral character issue, which really does speak to the Rahimi comment by the court that irresponsible people cannot be denied their Second Amendment rights. So that's the first category, the Antonyuk category. The second category of cases that the Supreme Court will be conferencing on Monday is a very, very, very big deal. That is the Harrell and Bevis cases out of the state of Illinois. There are a whole host of these these assault weapon, semi-automatic rifle related cases. They were all were basically screwed around by the anti-gun judges on the Seventh Circuit Court of Appeals, Judge Frank Easterbrook and Judge Diane Wood. You all know that. We covered it extensively as just how insane the decision was and how it deviated from Heller. And there was a dissent there, 2-1, against the Second Amendment, but there was a very strong dissent by a Trump-nominated judge saying this is a balderdash and silly, and it's inconsistent with Heller. But nevertheless, keep in mind that those assault weapon, and I use that as a political propaganda term by the anti-gun left, the semi-automatic rifle and magazine bans out of Illinois are also on an interlocutory appeal, meaning they are not resolved. There's no final judgment there. The one thing, though, that's interesting, and this is kind of significant, is that you do have a very long and extensive opinion by the United States Court of Appeals that really shows undeniably that the Seventh Circuit out of Chicago has absolutely zero idea of how to interpret properly the Second Amendment right to keep and bear arms or the Supreme Court's precedents in this area. It literally shows utter either disdain for the Supreme Court and their precedents, or it shows utter ignorance. And because Judge Wood and Judge Easterbrook are both very intelligent individuals, I think they're just being jerks and thumbing their nose on purpose at the U.S. Supreme Court and its precedents, and I hope the Supreme Court does something about it. So I think there is a chance that the Supreme Court will grant cert in one or more of those quote-unquote assault weapon cases. With that said, the odds of them doing so are not super high because it's on an interlocutory basis. Now, I want to just read something that just came out that relates to why I think it will be difficult for the Supreme Court to grant cert in those Illinois semi-automatic rifle and magazine ban cases. If you look at Justice Alito, Justice Thomas, and Justice Gorsuch dissent, Justice Alito wrote the dissent, and Justice Thomas and Justice Gorsuch agreed with and signed on to the dissent written by Justice Alito. In the Moyle versus Idaho, this is the Moyle versus the United States. This is the Idaho abortion case. You may recall reading about this in the paper. We haven't covered this that much in this channel. We probably should do an independent video of it next week. I will probably do that. But this is the issue where there's a federal Medicare, Medicaid law that generally says to take federal monies, a hospital has to do certain things, including protect the lives of the mother and the life of the unborn baby. And there was a question as to whether or not a set of restrictions by Idaho state law arguably conflicted with this federal statute, and who controlled the federal statute, which is a very generic statute involving medical care, or the very specific anti-abortion statute by the state of Idaho. There was a debate about which law conflicted and how it all worked out. And the Supreme Court ultimately granted cert, but then they denied cert. They basically said, we're going to deny cert. We're going to say this was improvidently granted, meaning we made a mistake because of a lack of standing and mootness. I won't bore you with the details right here and right now, but I just want to put that into a little bit of context because that tells you what I'm about to read. So Justice Alito dissented from the Supreme Court's decision in the Moyle case, which really was kind of a procedural issue. Again, I'm not going to get into that beyond this language from the dissent, which I think is telling and potentially a bad news for whether or not they're going to hear the quote-unquote assault weapon cases out of Illinois. This is what Justice Alito wrote, signed on by Thomas and Gorsuch. He writes the following: having already taken the extraordinary step, hear what I just said, quote, having already taken the extraordinary step of granting certiorari before judgment in order to decide whether the government's new interpretation of the federal law is correct, and go on and go on. The point is that Justice Alito was saying that taking a case on cert on an interlocutory basis is, according to his language in this dissent, the extraordinary step. He calls that decision to grant cert in that Idaho case on an appeal to the Ninth Circuit on an interlocutory basis to be extraordinary, which I think is not great, because if something's extraordinary, which means it's relatively rare, and that is my concern about those Illinois assault weapon cases, that the court may view those, because they're on an interlocutory basis, as extraordinary to grant cert, and they may just not do it, and they may want for the Seventh Circuit to finally ultimately resolve the case on a final judgment. With that said, I think the difference is that because the Seventh Circuit has already issued that 60, 70-page opinion on the Second Amendment in arms ban cases that's clearly wrong, I think it increases dramatically the odds that the Supreme Court might actually say something about that. So if you force me to bet, here is what I'm going to bet is going to happen, and this is just my speculation. I bet that the Supreme Court is going to deny cert to all those Illinois assault weapon related cases. It's not what I want to happen. I want them to take those cases. I think it's an easy case for us to win, but I think what's going to happen is they're going to deny cert on all those Illinois assault weapon related cases and magazine cases, but one or more justices is going to write some sort of dissent or some other comment or some other short opinion reminding the Seventh Circuit Court of Appeals and the lower courts in the Seventh Circuit that they better follow Heller and they better do the right thing and they better not screw up again, or they're going to get spanked. That is probably the best we can hope for. Obviously, what we really want is for them to take one of these cases, one or more of these cases on Tuesday. But again, if they don't do that, the next best alternative is they deny cert, but one or more justices writes some sort of short opinion telling the lower courts that they better get their act together, and they haven't done so yet in the Seventh Circuit. So that's where we are with the assault weapon cases and where they might stand. We will know a lot more on Tuesday, of course. The last category we've already done one video on, that is what I call the 922G cases that deals with prohibited persons. You all know those 922G cases. Specifically, as you may recall, the Rahimi case is a 922G case dealing with 922G8 domestic violence restraining orders. Now, these cases on Monday that are being conferenced that touch fingers with 922G are 922G1 cases, which is the so-called felon in possession statute. The reason why I bring this up is, if you may recall, after Rahimi was decided, the Department of Justice wrote an extensive brief saying that they think the court should take multiple cases touching on 18 U.S.C. 922 G1, just to clarify where the lines are. Remember, we know from Rahimi, and what I've also explained to you, I think the touchstone is always going to be on 922G cases is, are you a violent danger to yourself, or are you a violent danger to someone else? And has there been a factual finding by a court that you are such? That's really what Rahimi said. Now, with that said, what I think is going to happen here is the Supreme Court, I suspect, is going to take one or more of these 922G cases. The one case I think they're the most likely to take is what I call the absolute factually opposite case from Rahimi. If you may recall, Zaki Rahimi was an utter terrible person. He engaged in not only hitting his girlfriend's head against the dashboard of the car, he also shot at a witness to that event and then got a restraining order against himself, which he admitted that he was a danger to society and to others. And then he goes out and engages in five other shooting events after the restraining order. So this is not a good character, clearly a violent nut job, and is in prison, I believe, as we speak. Now, so I would think that if I were on the Supreme Court, I would look to take the polar opposite case. You've got the most extreme case of a violent guy. Take the polar opposite case of the opposite end of the spectrum, and that would be the Brian Range case out of the Third Circuit Court of Appeals. Here's a guy that on the record has never hurt a fly. He lost his gun rights back in the day because he pled guilty to some sort of food stamp related welfare fraud by failing to disclose all of his income. And he pled guilty to this, which technically was a felony under federal law, but there was no violence at all involved. So I think if the court took the Range case, or a case like Range, you would have one extreme of violence, bad facts, which is the Zaki Rahimi case dealing with 922. And then you would have the other extreme, the Brian Range case, of somebody that is, good, if you will, not violent, non-violent, like Martha Stewart types. I think that would be what the court will be looking to do. And they may grant some other 922G cases so they can kind of identify where on the spectrum of very violent on the one hand to very not violent on the other hand, and whereas like a drug dealer, whereas a drug user, whereas a marijuana user, whereas someone that was violent 20 years ago but isn't violent today, then they can start maybe filling in the blanks as to where these particular cases fall on the spectrum of absolutely violent on the one hand versus absolutely not violent on the other hand, and then start putting other cases in the middle. Now, I don't know what the court's going to do, but I do think they're probably going to take one or more of these 922G cases because the Solicitor General under Joe Biden has asked the court to do so, and they usually will take a case if the Solicitor General of the United States asks them to do so, which in this case, the SG's office has asked them to take one or more of these cases dealing with 922G. So there you have it, folks. So we will know a lot more on Tuesday after the Monday conference by the U.S. Supreme Court. Remember, the Supreme Court needs four justices to vote to hear a case before cert is granted. So we'll find out whether or not there are four or more justices that are willing to hear a case and will vote to grant cert in the Antonyuk case, or the assault weapon cases out of Illinois, or the 922G cases dealing with prohibited people. But that's kind of where we are. The good news, I think we will know all about what's going to happen no later than Tuesday when the order list comes out, and hopefully we get some good news there, but only time will tell. All right, folks, hope this was not too geeky. Hope you enjoyed the show. Make sure you follow me on X at 4Boxes Diner. Please subscribe if you've not done so already here, and we will see you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.